They thought I was finished. I could see it in the way my son-in-law leaned back in his chair at the defense table, one arm draped over the back like he was watching a football game. I could see it in the way my daughter didn't even look at me when I walked through the courtroom door. Not once. She just whispered something to her attorney and smiled. I was 64 years old, wearing a gray jacket that didn't quite fit anymore because I'd lost weight I hadn't intended to lose. I had no attorney sitting beside me. I had a manila folder, a yellow legal pad, and a pen that kept skipping. They had 3 lawyers. Let me back up. My name is Norman. I spent 31 years building a commercial roofing business in Central Ohio. The kind of work that nobody glamorizes, nobody makes movies about, but that pays well if you're disciplined and honest and show up when you say you will. I started with 1 truck, 1 helper, and a used nail gun I bought off a guy at a flea market in Chillicothe. By the time I was 55, I had 22 employees, contracts with 3 hospital systems, and a reputation in the trade that I was quietly proud of. My wife passed in 2019, breast cancer. Her name was June, and she was the kind of woman who kept a running grocery list magnetized to the fridge and somehow always knew when you needed a cup of coffee more than you needed advice. When she died, something in me went quiet. Not broken, exactly, just quiet. My daughter Stephanie was 31 then. She'd moved to Columbus after college, married a man named Tanner who sold commercial real estate and wore his watch too tight. I never disliked Tanner. That's the honest truth. He was pleasant enough at holidays, remembered my birthday, coached my grandson's little league team. I had no reason to distrust him. That was my first mistake, trusting by default. After June died, Stephanie started calling more. She'd come by on weekends, sometimes with the kids, sometimes alone. She'd cook dinner, clean up, sit with me on the back porch while I watched the tree line go dark. It felt like we were getting closer. I thought grief was doing that, pulling us together the way it sometimes does. What it was actually doing was giving her a clear view of what I had. The business was worth somewhere between 2.3 and 2.8 million, depending on the year and the contracts in the pipeline. I also owned the commercial property it operated from, a 2-acre lot with a metal building I'd put up in 2004. The house June and I had lived in for 26 years, sat on 4 acres outside of Lancaster. Paid off. And I had retirement accounts, life insurance proceeds from June's policy, and a small investment portfolio that a financial advisor in Columbus had been quietly growing since 2011. I was not a rich man, but I was not a poor man either. Stephanie knew all of this because I had told her, because she was my daughter and I trusted her, and June always said we should be transparent with family about these things so nobody gets blindsided later. June was right about most things. She was wrong about that. About 8 months after June passed, Stephanie sat down with me at the kitchen table and told me she was worried about me managing everything alone. The business, the properties, the accounts. She said she and Tanner had been talking. She said Tanner had experience with business finances and had some connections with the state attorneys, and wouldn't it make sense, just for peace of mind, to get some of the paperwork organized? I said yes. I said yes because I was tired and sad and she was my daughter and it sounded reasonable. Over the next 14 months, I signed things. I want to be careful here because some of it I understood at the time and some of it I thought I understood and some of it I simply did not read carefully enough. Because I trusted the person handing me the pen, a limited power of attorney for business decisions while I was recovering from grief. A revised beneficiary structure on 2 of my accounts. A property management agreement that put Tanner's LLC in charge of the commercial lot. A consulting agreement that paid Tanner's company a monthly retainer from the business operating account. I signed them in my own kitchen. My daughter made coffee while I signed. The first time she held my hand afterward and said, "Dad, this is just so we can help you. You know that, right?" I knew it. I believed it. I was a fool. The thing that woke me up was not dramatic. It was a phone call from my accountant, a man named Gerald who had been doing my taxes since 1998. He called me in March, 2 years after June died, and said, Norman, I need you to come in and sit down with me. There are some things in these business statements that aren't adding up, and I think you need to see them in person. I drove to Gerald's office on a Tuesday morning. He had printed out 27 pages and laid them on the conference table in order. The consulting fees to Tanner's LLC totaled $340,000 over 22 months. There were equipment purchases I didn't recognize, a lease modification on the commercial property that had quietly reduced my ownership stake, 2 wire transfers to an account I did not know existed, totaling just over $90,000, authorized under the limited power of attorney I had signed. Gerald slid a piece of paper across the table. He didn't say anything. He just let me read it. I sat in that conference room for a long time. Gerald got up and got me a glass of water and closed the door on his way out, which is something I will always be grateful for. Because I needed to be alone for a few minutes with what I was looking at. My daughter had helped her husband steal from me, not carelessly, not impulsively. Systematically over nearly 2 years, using documents I had signed in my own kitchen while she made coffee. Here is the thing about betrayal when it comes from your child. It doesn't feel the way people think it will. It doesn't feel like rage, not at first. It feels like a structural failure, like a load-bearing wall in your chest just gave out, and everything that was resting on it, memory, love, the version of your life you thought you were living, all of it shifts and settles wrong. You sit there and you think, was any of it real? The Sunday dinners, the calls on my birthday, the way she cried at her mother's graveside and gripped my arm. Was all of it positioning? I don't know the answer to that question. I still don't. What I do know is what I did next. I did not call Stephanie. I did not call Tanner. I drove home. I fed my dog, a beagle named Buckwheat, who had been June's dog first. And I sat at the kitchen table with a legal pad, and I started writing down everything I remembered. Dates, conversations, the specific words people had said to me, every document I had signed, and what I'd been told it meant. Then I called a man named Arthur Peck. Arthur was not a flashy attorney. He was 68 years old, worked out of a small office above a dry cleaner in Lancaster, and had been handling business disputes and estate litigation in Fairfield County for 30-some years. He wore the same style of corduroy sport coat in 4 different colors and kept a bowl of butterscotch candies on his desk. I had used him once before, years ago, for a contract dispute with a supplier. He had won. I called him on a Wednesday. He saw me on Friday. I laid the 27 pages on his desk. He put on his reading glasses and went through every single one without speaking. It took 40 minutes. I ate 3 butterscotch candies. When he was done, he took off his glasses and set them down and looked at me. He said, "Norman, how much do you want to fight this?" I said, "All the way." He nodded once. He picked up his glasses. He said, "Then let me make some calls." What followed was 8 months that I will not fully describe because some of it is still sensitive and some of it was simply grinding, depositions, document requests, forensic accounting reviews, back and forth between lawyers that produced very little visible progress and very large invoices. Stephanie and Tanner retained a firm out of Columbus, 3 attorneys, the kind of practice with a website that has aerial photography and a client list that includes regional banks. I had Arthur Peck and a bowl of butterscotch candy. During those 8 months, Stephanie called me twice. The first call she cried and told me I was being manipulated by Gerald and that everything Tanner had done was with my best interests in mind. And why was I letting strangers poison our relationship? The second call she didn't cry. She told me that if I continued this, I would regret it and that her children, my grandchildren, would grow up knowing that their grandfather chose money over family. I listened to both calls. I said very little. I wrote down what she said in my legal pad. I want to be honest about something. There were nights during those 8 months when I thought about dropping it, not because I believed I was wrong, but because I was tired, and because the weight of what I was doing, suing my own daughter, felt like something I would carry for the rest of my life regardless of outcome. There is no version of this that ends clean. You don't get your family back. You don't get the kitchen table back, the coffee, the hand on yours. Even if you win alone. I kept going because of something Arthur said to me in his office on the Thursday in October when I told him I wasn't sure I had the energy to continue. He leaned forward and he said, "Norman, the people who did this to you were counting on exactly that feeling. They built their plan on the assumption that you would get tired. Don't give them that." I went home and fed buckwheat and went to sleep and got up in the morning. The hearing was set for the second week of February. It was a civil proceeding, breach of fiduciary duty, fraud, unjust enrichment, not a criminal trial, though Arthur had also filed a separate complaint with the county prosecutor's office that was moving on a parallel track. The hearing was in a courtroom in the Fairfield County Courthouse, a building I had driven past 3,000 times without ever expecting to walk into. I got there early. I wore a dark blue suit that June had picked out for me years ago for a Chamber of Commerce dinner. It still fit. I had gotten my hair cut the week before. I sat at the plaintiff's table with Arthur, who had a yellow legal pad of his own and a mechanical pencil, and I looked straight ahead. Stephanie and Tanner came in with their 3 attorneys. She was wearing a cream-colored blazer and her hair was done. She looked like she was attending a business lunch. Tanner was in a charcoal suit. He looked confident. They sat down at the defense table and Stephanie looked at me, the first direct look since this started, and I saw something in her face that I can only describe as contempt. Not guilt. Not sorrow. Contempt. Like she still expected to win. Their lead attorney opened by painting a picture of a grieving widower, overwhelmed and isolated, who had invited his daughter and son-in-law to help manage complex financial affairs he no longer had the capacity to handle. Every document I signed was presented as evidence of that invitation: the power of attorney, the property management agreement, the consulting contract. Each one offered freely, they argued, by a man who knew what he was signing. It was a plausible story. I will give them that. They had clearly practiced it. Their attorney was smooth and prepared and spoke in the measured, reassuring cadence of someone who has stood in front of judges many times. When he finished, Tanner leaned over and said something to my daughter and she nodded. She almost smiled. Arthur stood up. He is not a dramatic man. He doesn't perform. He speaks in a flat, deliberate tone that sometimes makes people underestimate him, which is, I have come to believe, entirely intentional. He said, "Your Honor, we have submitted a binder of documentary evidence and I'd like to walk through it methodically." The binder was 112 pages. Arthur had done something in those 8 months that I hadn't fully understood until I was sitting in that courtroom watching it unfold. He had not just documented what Tanner had taken, he had documented the timeline of how the plan had developed, starting before June died, with a series of emails between Stephanie and Tanner that had been recovered in discovery. Emails discussing my assets, my age, what they called in one message, the window. He had a forensic accountant who walked through each transaction, not just the amounts but the mechanisms, the way the consulting fees had been structured to stay just below the threshold that would have triggered automatic review. The wire transfers moved in 2 installments to keep them under reporting requirements. This was not improvisation. This was deliberate. And then Arthur said, "Your Honor, I'd like to enter into evidence Exhibit 47. Exhibit 47 was a letter. I had written it myself. Not in anger. I had written it in January on a Sunday morning, sitting at the kitchen table with buckwheat asleep at my feet. I had written it to Stephanie. Not the legal version, not the deposition version, the real one. The one that said, "I know what you did. I know when it started. I know you did it while your mother's grave was still fresh and I was still sleeping in a bed that smelled like her. I know all of it, and I have kept records of all of it, and I need you to understand that I am not the man you decided I had become. I am still the man who taught you to ride a bike in the parking lot of the Lancaster YMCA. I am still here, and I am not afraid of you." Arthur had submitted it as a character exhibit, evidence of my state of mind, my clarity, my full awareness of what had been done. The judge read it. She read the whole thing, slowly, without expression. The courtroom was very quiet. When she set it down, Tanner's attorney started to stand. The judge raised one hand, just slightly, and he sat back down. She looked at the forensic accountant's summary. She looked at the emails. She looked at the letter again. Then she looked at Stephanie and Tanner. She said, "I want to make sure I understand the timeline here correctly." And she began to ask questions, specific questions, detailed questions about dates and account numbers and who had authorized what and when. Their attorneys answered some of them. Tanner answered 2 of them and then stopped answering. Stephanie looked at the table. The judge called a 15-minute recess. When she came back, she sat down, adjusted the papers in front of her, and delivered her findings. She ruled in my favor, on every count. She ordered the disgorgement of all funds taken through the consulting agreements, $340,000. She ordered the unwinding of the property lease modification. She restored the beneficiary designations on my accounts. She awarded additional damages for attorney's fees. And then she did something I had not expected. She referred the matter to the county prosecutor's office for criminal review of the wire transfer transactions, noting that the evidence presented suggested conduct that may rise to the level of financial elder abuse under Ohio law. She said this in a flat, factual tone. She didn't raise her voice. She didn't editorialize. But the word she used, elder abuse, landed in that courtroom like something solid hitting a floor. Tanner's attorney was on his feet immediately, objecting to the characterization, asking for clarification. The judge said, calmly, that she was not characterizing anything, she was observing that the evidence warranted review by the appropriate authority, and that it was now in the record. I looked at my daughter. She was not looking at me. She was staring at her hands flat on the table. Tanner was whispering something furious to his attorney. The 3 lawyers were conferring in low voices. Arthur gathered his papers into a neat stack and clipped his mechanical pencil to the top of his legal pad. He did this slowly and deliberately, the way a man does when he is not in a hurry. He leaned over and said quietly, "Let's go." We walked out of the courthouse together, through the main lobby, out the glass doors, into the cold February air. There was still snow on the ground from a storm 2 weeks earlier, gray and compressed at the edges of the parking lot. We stood outside for a minute. Arthur unwrapped a butterscotch candy from his coat pocket. He offered me one. I took it. He said, "You did a good job in there." I said, "You did a good job." He said, "I had good material." We stood there for another moment. I thought about June. I thought about the kitchen table and the way she used to keep that grocery list on the refrigerator. The magnet shaped like a pineapple from a trip we took to Hawaii in 2003. I thought about Stephanie at 10 years old in the YMCA parking lot, wobbling on her bike, hands off the handlebar for 3 feet, 4 feet, laughing. I thought about buckwheat weeding at home. I thought, you don't get your family back. That part was true. But you get yourself back. You get to be the man who did not simply hand over everything he built and go quiet into whatever they had planned for him. The criminal matter is still pending as of when I'm telling you this. The prosecutor's office has been in contact. I don't know what comes next. I've stopped trying to predict. What I know is that I went into that courtroom alone at 64 years old in a suit my wife chose for me, and I walked out with everything I had built. Still mine. They thought I was finished. I had barely started. I keep coming back to the moment Gerald slid that paper across the conference table. Not the courtroom. Not the gavel. That quiet Tuesday morning in a small office above a dry cleaner. A man who had been doing my taxes for 25 years looking at me over his reading glasses. Not saying a word because the numbers already said everything. That moment was the hinge. Everything before it, I had been living inside a story someone else was writing for me. Everything after, I was writing it myself. People ask me, when I tell this story, whether I felt angry. The honest answer is, not the way they expect. The anger came later, and it was cold and clear, not hot. What I felt first was something closer to shame. That I had let it happen. that I had confused kindness for trust without verifying the difference, that I had signed documents in my own kitchen because I didn't want to believe that the person pouring my coffee could be the same person taking my life's work apart piece by piece. That shame taught me something I wish I had learned earlier. Integrity isn't just about what you do, it's about what you require from the people around you. June and I built everything we had, honestly, and I assumed the people closest to me shared that standard. I stopped checking. I stopped asking questions. I let grief make me passive, and passivity, I learned, is its own kind of decision. Tanner and Stephanie didn't stumble into this. They planned it. The emails Arthur recovered showed they had begun discussing the window before June was even gone. That kind of calculation doesn't happen by accident. It requires a person to look at someone they love and decide that what that person has is more important than who that person is. That's a moral collapse, and it has a cost. It always has a cost. Not because the universe punishes wrongdoing in some mystical way, but because the choices you make determine the person you become, and the person you become determines every outcome that follows. They built their plan on deception, and deception is structurally unstable. It requires constant maintenance, it leaves records, it has gaps, and when someone patient enough goes looking, when a Gerald calls, when an Arthur starts pulling on threads, it comes apart. What I did in those 8 months wasn't remarkable. I showed up to Arthur's office. I answered questions honestly. I kept my legal pad. I didn't call Stephanie to threaten or confront. I just kept going one Tuesday at a time, on days when I felt like stopping and on days when I didn't. That steadiness, not brilliance, not luck, is what won. The forensic accountant found what he found because we gave him time to look. The letter landed the way it did because I wrote it with a clear head, not a rage-filled one. I think about that sometimes. The letter. I wrote it on a Sunday morning with buckwheat asleep at my feet, and I wrote it slowly, and I wrote it as truthfully as I knew how. That's all it was. Truth, written down and submitted at the right moment. I was 64 years old, sitting at that plaintiff's table. I didn't have 3 attorneys. I had Arthur and a bowl of butterscotch candy, and 31 years of showing up to jobs I said I would show up to. That's the only inheritance that actually held. The criminal matter is still pending. I don't know how it resolves, but I know that I walked out of that courthouse in the suit June picked out for me, and the building I built is still mine, and buckwheat was waiting at the door when I got home. Some things you can't take back. But some things, if you're patient enough and honest enough and willing to keep going when you're tired, you can.